to meet up at 9 o'clock, all right? So we'll start at 10. I hope all of you have a really nice evening. Thank you. Please be seated. We had an in-chambers conference concerning some exhibits. I have directed the state to look through the autopsy photos and eliminate any duplicates. I've also directed the state, if they want to show photographs where Daunte Wright's eyes were open, that it would have to be cut off at the nose level. My reason for ruling that way is that it evokes the sympathy of the jury, and the jury is not supposed to be deciding this case based upon sympathy, passion, or anything of that sort. And then, Mr. Ng, you wanted to put your objections on the record?
Yes, I did. The defense has a concern about the presentation.
I think you need to use the microphone. So.
The defense
You should use the podium, Mr. Ng, because the court reporter is at the end of the day, and
the defense has expressed a concern about the presentation of the state's case. The issue in our case here is the thought process of Kimberly Potter at the moment that she yelled taser, 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 and pulled the trigger of her gun. We have spent the day, rather, on an accident that was caused by Daunte Wright's excessive speed. We've heard from the elderly couple, the wife and the daughter, in very sympathetic testimony. And then we've spent an unending, it seems, amount of time on that aspect of the case without any time addressed to the gravamen of why we're here. There is a body of evidence that holds that where the state spends an inordinate amount of time presenting prejudicial evidence that has little relevance to the elements of the particular offense, that the defendant is prejudiced. I believe the federal case, the classic federal case, is Engelman, as I recall, E-N-G-L-E-M-A-N. I can get a cite later for you. But that's our concern. And as I sat with Mr. Gray and watched this is the great advantage of being a second chair, in a sense. I didn't see any evidence directed towards the proof of guilt today, but rather evidence of sordid pictures and prejudicial impact that had little relevance. To the extent this is a Blakely issue, it still doesn't override, in terms of time and attention, what really matters in the case, which is whether the state can prove the elements of the offense. Therefore, I move for a mistrial.
As the court is aware, the state filed a Blakely notice, which is a notice that the state intends to seek a lengthier sentence based on factors in the particular case. We have alleged both Officer Potter's, and the reason I say Officer Potter is intentional there, because she was an officer at the time, and her role as an officer was a violation, presented a violation of trust and authority. and we alleged that as one of the aggravating factors. The other is that her conduct presented danger to more than just the individuals in the immediate area. It presented a greater danger to a number of people. And the court and counsel for the defendant agreed that we would try the Blakely issues in a unitary trial and not a bifurcated trial. And so a lot of the evidence that, well, some of the evidence that we presented today was relevant to those Blakely factors. The injuries to the Lundgrens was not something we offered gratuitously or because we wanted to inconvenience the Lundgrens. Certainly, we offer that evidence because it is proof of that Blakely factor because of the danger to others. So that information was directly relevant to our case and had no objection at the time, only upon reflection later, apparently, that it was not good for them. The other matter, Your Honor, regarding the medical testimony, as you recall, the defense, Mr. Gray, filed a notice of defenses that included causation. And in public filings, Mr. Gray has challenged, essentially asserted that Mr. Wright caused his own death, that somehow he was responsible for the bullet that entered his chest and blew up his heart. And, Your Honor, we have heard arguments about that in chambers, and we have also heard arguments, as Mr. Eng just makes, that the injuries were caused by his excessive speed. Our theory of the case, of course, is that the conduct at issue, the elements of the offenses based on allegations of Ms. Potter's behavior that day were reckless. And that means a risk of harm. And the harm was not only to shooting Mr. Wright in the chest from 2 feet away, but also in a position to operate a motor vehicle, which then drove out of control, which is the exact danger that is one of the concerns that she had to be aware of, and caused a crash and harmed other people. It wasn't Mr. Wright's excessive speed, it was the fact that he was shot in the chest while he was in a position to operate the vehicle. So the defense has their theory of a case, we have ours. The death is an element of the offense, and so causation is always relevant to that element of the offense. And so we are also presenting what we feel is the necessary medical testimony to establish cause of death. And so, Your Honor, all of this evidence today was admissible and relevant to those issues. It certainly doesn't rise to the level of a mistrial that is a remedy I'm hearing for the first time when Mr. Eng argued. So we would ask the court to find that if this was some kind of post hoc objection, to overrule it and to deny any request for a mistrial, and let's get the trial moving.
Your Honor, I'd just like to respond to it. If that's the state's position, then I'm anticipating that in their final argument, they aren't going to argue Blakely issues to the jury about these other folks getting injured. If that's why he's introducing this evidence, the court has heard the evidence, and the court can decide the Blakely issues. But if he starts arguing this to the jury, it's objectionable just by what he said just now. Thank you.
All right. We're really getting ahead of ourselves right now. First of all, the motion for a mistrial is denied. With respect to Blakely, my understanding was that was going to be submitted to me for my decision. Am I incorrect on that?
No, that is correct.
Okay, the defense wants me to decide the Blakely issues. Okay. All right, we're going to start up at 10 o'clock. Okay, thank you, counsel.